she's not gonna. No, she's not gonna make us.
You don't need to tell your mother what I said. Get back on this screen. Turn your camera on now! Send them out of the room! Send those two girls out of that room! Now! Don't say a word, just send them out of the room. Oh, and go ahead and put yourself on mute now.
Bosky, so we'll start with position 4. Bostic, you still there? Or you still in NC1?
I'm finally done.
Okie dokie. You were just BC'd on something.
What? What?
You were just blind copied on something. All right, here we go. We will start this off with position 4. Calvin Coley, 23 CP 220423, 652 days without indictment as of June 7th. There's a $20,000 good bond. And from what I understand, well, Bostic will go, there's another open case that he just pled on another case in May, was sentenced to 12 months probation.
16 cycles, 2012 robbery, contributing to delinquent and crossing guard line. Open case 24 PI 000942 act assault. Prohibited item by inmate FTN 22, unauthorized possession by inmate in Cobb 8923, 221 days confinement, 4 years 114 days probation. In Cab act assault simple battery 4/8/2822, 18 months confinement, 6 years 6 months probation. There's interference with government property. That's on that other case. That's fired by a convicted felon in 2018. Nothing further.
All right, go ahead, Mr. Showalter.
Okay, so Calvin Coley, he is 32 years old. If released, his address will be 143 Hillsdale Drive, Atlanta, Georgia, 30315. He would be there with his mother. He is an Atlanta native. He's got his entire family here. He has a GED. He was previously working at the Georgia World Congress Center as a cook. He has that available to him. He's been speaking with them, but also he is looking to get a CDL. A friend of his runs CDL classes, and they're pretty much waiting on him. They would like him to start working for him. So on this charge, it is a $20,000 bond, and considering his long incarceration and that he does have ties to the community, he does have things he's looking to do, places to be, place to stay, I would ask the court to lower it to a $5,000 bond.
Ms. Dorsey Jones, have there been any victim contact?
No, Your Honor, it has not.
All right, go ahead, Ms. Jackson.
Judge, I believe Madam Pretrial's rendition of this criminal history spoke a lot for itself. 2009 robbery, 2010 robbery, contributing to the delinquency of a minor, multiple drugs with intent, a 2022 battery upon a pregnant victim. This Mr. Coley is an extremely violent person in nature, and his history reflects that he is likely to reoffend and will remain a danger to the community. For that reason, Judge, we would ask that the bond stay at $20,000.
All right, we got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Sir, you're going to have a 24-hour curfew. You will stay at your house unless you have court, meetings with your lawyer, medical appointments, or work only. But you have supplied the name of your employer, proof of employment schedule, and the exact location you'll be working. No further contact with Raymond Strozier. I'll make it a $15,000 good bond. I'm going to put this on my email to Ms. Willis today. Thank you, sir.
And Your Honor, may I make an announcement on position 5 and 11? This is Attorney Guest. It's my understanding that position 11 has been indicted in position 5. Just wanted to confirm that that had been closed. I believe it was merged into an open case for Mr. Swanson. Is that your understanding as well, Your Honor?
Right, transferred to McAfee.
Yes, Your Honor.
Yeah, that's it.
Okay, well, that concludes my matters with the court. May I be excused?
Yes, ma'am. Have a good one.
Thank you, you too.
Marietta, do y'all have heat and air? Y'all have air? It's cool in there? All right, let's see. We don't have Cobb yet. All right, let's see. We'll take Marietta position 1 real quick. That's James Crooks. So it's 24 PI 003078. 96 days without indictment. There's a $17,500 split bond as of May the 6th for burglary of the first degree, theft by receiving stolen property, possession of drug-related objects, possession of cocaine with intent to distribute, possession of methamphetamines with intent to distribute, and possession, manufacture, distribution, sale of marijuana. Wow. Go ahead, Bostic. You're on mute, and I did not mute you.
Hey, nap it. I was almost done. Okay, start over. 6 arrests in Missouri, felony drugs in the 90s, 2 in New Jersey, 4 in Texas, a felony escape in 04, 13 in Georgia, DUI in 2019, terrorist threats 2016, battery, family violence 2016, drugs in 02, open case 23, CP 218647, ag assault, nothing further.
All right. Go ahead, Ms. Zafarasi.
Judge, I'm sorry. What case was this for?
This is Crooks.
Oh, okay. Judge, he has been accepted into that program that I sent you guys out in Macon County. That's really the program we want him to go to. He's 43 years old. He does have family that lives here in Atlanta, Georgia, but like I said, he'd be housed in that program in Macon. He's been in Georgia since 1999. He moved here for work. He has family here, his dad, his brother, his son. He has a 16-year-old son that lives here. He is a high school graduate. He has his AA in applied science. He also went to the Everest Institute and he got a certification as an electrician. At the time of his arrest, Judge, he was working. He was working in Atlanta Auto Bistro, and it's on 4th Street. And he's a details cars, cleans them. He also does food delivery jobs, and he's been doing that for 5 years. So he has stable income, Judge. He does need to work in Fulton County, though, so we would request there not be a stay away, at least for the exceptions for work. And Judge, we do have some substance abuse issues. That's why we have the program. He wants the program. There are some things that came out in probable cause hearing. I'm not going to get into great detail about it, but essentially, Judge, a lot of this falls on the testimony of a co-defendant. And my understanding is the co-defendant who is on video that actually committed the burglary. Mr. Crooks was nowhere near the actual incident of the burglary. So, Judge, we're asking for a total bond not to exceed $50 total. He has a friend that's going to come up and post the bond for him and drive him to Macon. But like I said, to the program directly. But if you feel more comfortable, I can do a transport order to the program too, Judge. But really,
Right.
we want the bond to decrease. I would ask for signature, but due to this burglary charge, we can't. But we need the bond to go down, Judge, because we have a program ready to help him with some of his issues. So that's our position.
How long's the program? Because it says he can't work while he's in the program.
I think it's they're typically 6 months. I'd have to confirm with my social worker, but he won't. Whatever, he's going to comply with the program first, and then go back to work after that, Judge.
All right, go ahead, Ms. Jackson.
Judge, the letter that was sent out by Ms. Zafarasi says that the program is 12 months, and as you stated, it says that he wouldn't be allowed to work during that time. The state would be highly opposed to reducing this bond down to $50. Mr. Crooks has a very extensive criminal history. Ms. Bostic just summarized that for us. An extensive history of charges that are similar to the ones that are here on the calendar today. Mr. Crooks is extremely likely to reoffend, and he's an extreme danger to this community. While the state acknowledges and is grateful that Mr. Cooks was kind of conditionally accepted into a program, as it does say that barring any unforeseen circumstances and based on availability, he will be welcomed. I wouldn't consider this necessarily an acceptance letter. It also doesn't have a signature at the bottom where it normally would have one. And so the state would not accept this as an end-all be-all acceptance letter that would require some type of $50 bond on a case such as this one. For that reason, the state will request that the burglary, if anything, be reduced to $2,000 from $2,500, $2,500 on the theft by receiving stolen property. There appears to already be a UJR on the possession of drug-related objects. We would request a bond to stay at $5,000 on the possession of cocaine with intent, $5,000 on the possession of methamphetamine with intent to distribute, and would consent to keeping the UJR the same on the possession of marijuana.
All right.
And
We got-
just I would ask you to look at those amounts of the drugs alleged. We're talking 2 grams, 2 grams, and 8 grams of weed. We're not talking about a huge amount. I just would point that out. And I got that letter from my social worker. She got it directly from the program. If Your Honor would like a signed, that's what they emailed us. But if you would like a different letter signed by them, I can provide that within the next day, Judge.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Donald Gray, your co-defendant. No further contact with the alleged victim, Neil Patel. Stay away from 275 10th Street Northeast in Atlanta, Georgia. Must participate and complete in the rescue mission program. So I think it's a 6-month program. And while you're in the program, you got to stay out of Fulton County unless you're here for court, lawyer, or to see a doctor. That's the only reason you come back to Fulton County. And once he's completed the program, Ms. Rossi, send me a bond order and I'll allow him to come back to work and stuff. Okay.
All right. You understand that, Mr. Kirks?
No, I didn't.
Okay, so for the first 6 months while you're in the program, she's not gonna let you come back to Fulton. So you got to find a different job out there in Macon, okay? And then after 6 months, once you complete the program, judge says we can modify and you can come back to Fulton to work, okay?
Yes, ma'am.
Well,
Okay.
it says on the letter that he's not allowed to work while he's in the program.
So you probably can't work either way. You probably work through the program anyways, okay? A lot of
Yes.
times, judgeless programs, you work with the program, and that's how you feed yourself for the housing that they.
Yeah, okay, because it just says, what does it say?
That's probably no third party work, but he
Well,
will be
that's a-
working with the program usually. That's how they.
Well, you can do
Right.
whatever the program has you doing, but you can't go get a job. All right.
Yes.
All right. Let's see. Supply your address where you're going to be going. Ms. Jackson, what's your position on have them transport?
I'll leave that in the discretion of the court judge.
All right, we'll let Rescue Mission transport. So if you send me a transport order, I'll sign that. They'll transport you directly there, sir. We got 2,000, 2,500, UJR, 2,500, 2,500, and UJR. Best of luck to you, sir.
Judge, what's that a total bond of? You went fast. I think I missed someone.
2,000, 2,500, 2,500, 2,500. So that's 9,500.
Okay, 9-5. All right. Thank you, Judge.
All right, best of luck to you, sir. You can lay the
All right.
boot. All right, Irvin Alexander. Position 6, Gibson. So we got position 6 is 24 PI 003071, 96 days without indictment. Right now there is a $3,000 good bond as of May 3rd on possession of scheduled controlled 2 substance and theft by shoplifting. Pre-trial. You on mute, Bostic.
11 cycles. No felony convictions, a couple of misdemeanor theft by shoplifters in 2022. Open case 24 PI 001984 for theft by taking. Nothing further.
All right, go ahead, Ms. Gibson.
Yes, Judge. Mr. Alexander is 39 years old. He has been in custody for 96 days without indictment. And as pretrial stated, he has no felony convictions. He has family in North Carolina. However, he's lived in Atlanta for 6 years and has developed lots of connections and friendly relationships here. He moved here for work. He works for North Star Moving Company. It's out of Florida, but Atlanta was more central, which was the reason that he came here, so that he could be, somewhat close to work and close to family. He works for multiple moving companies out of Atlanta as well. He has 2 children in North Carolina. He also has a grandbaby who should be about 6 or 7 months old by now. He would love to get out and meet her. He got his GED in 2001. He did a semester at Granville Community College. And as you can see, his bond has been at $3,000 and he's not been able to make that for 96 days. So I will be asking for a considerable reduction, considering the charge in this case. I will ask that Mr. Alexander's bond not exceed $500.
Is he gonna live in Fulton County when he gets out?
He will live in Fulton County, Judge, because this is where he works, and he can get all of those jobs back where he's working with moving companies in the area.
All right. Go ahead, Ms. Jackson.
Judge, Mr. Alexander does appear to have quite an extensive criminal history. He's got multiple shopliftings in Georgia, but most importantly, he's got a pretty extensive history in North Carolina, which include similar thefts, some drugs with intent to distribute, and some obstructions. For that reason, we do believe that Mr. Alexander is likely to reoffend and would be considered a considerable flight risk, considering he has open cases in North Carolina from just as recent as 2022. For that reason, and based off the facts alleged in the warrant and the basis of what is alleged to have been stolen, the state would consent to decreasing the bond. As to count 1, we would consent to going from $2,500 to $1,000. And as to count 2, the theft by shoplifting, from $500 to $300.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3535 Peachtree Street. That's the Target. You have to stay away from all Target stores. You cannot go into a single Target store all over this country. So I got 1,000 and 100. Best of luck to you, sir. Let's see. Is Cobb there yet? Not yet. All right, let's see. Do we have Khalil Garrison? Oh, and Miss Gibson, make sure if you folks have anybody that's in over 90 days, you too, Miss Sofrossi, tell your office to email Mr. Dukes, not somebody's been in 20 days, like over 90 days that we need to hear on a bond, okay? So pass it on. All right, let's see. Mr. Garrison, wave your hand. All right, we got position 2, Bostic 24, PI 003153. 94 days without indictment. Right now, there is a $1,300 good bond as of May 6th for burglary in the first degree, criminal trespass, misdemeanor obstruction, and loitering and prowling. Pre-trial.
Judge, in regards to Mr. Garrison, he has a hold for probation violation out of Lawrenceville, 11/29/23, out of Canton for probation violation, 10/25/23. Open case for ride in a penal institution out of Fanning County, 7/19/23. On probation, criminal damage to property, theft by taking, 2/13/25 years. First offender, there's a DUI in 23, a couple of FTAs, 23 and 21. Nothing further.
All right, go ahead, Mr. Dobbs.
Thank you, Judge. The bond for Mr. Garrison is obviously on the lower side at this time. However, because of those holds mentioned by pretrial, he's not eligible for any bail assistance whatsoever. Of course, one of his charges is bail restricted, at least one, which is the burglary. Judge, what the warrant states, what the allegation is regarding his burglary charge is that he was entered a empty dwelling to charge his cell phone. I understand that allegation is a felony allegation. It is a allegation of illegal activity. But as far as a burglary goes, and as far as a felony goes, I would posit to this court that it is on the lower end of the criminal spectrum. Mr. Garrison moved here with his brother about 2 years ago. If released, he would reside with his brother at on Lexington Drive in Lawrenceville, Georgia. He is largely unable to work because he has various problems caused by a bad car accident he was in 2 years ago. Judge, I'm going to ask for a significant reduction on this case. He currently has a $1,000 good bond along with three $100 good bonds. Because of the nature of the offenses as well as the amount of time that he has been in to this point, I am going to ask for the $1,000 bond to be reduced to $300 through the sheriff's 10% program, and that the three $100 bonds be converted to the sheriff's 10% program. Thank you.
Go ahead, Ms. Jackson.
Judge, can you tell me how many days Mr. Garrison's been incarcerated?
94.
Okay. Judge, there are a couple FTAs in this case, some charges on the calendar that seem to be pretty similar to what we have. I do agree with his attorney, Mr. Dobbs. Based off the nature of this case, the state would go ahead and consent to Mr. Dobbs' request.
So was that 500 you said, Mr. Dobbs?
I said a conversion on the $1,000 to $300 through the sheriff's 10% program, and a conversion to the sheriff's 10% program for the other three bonds. Thank you.
All right. Sir, you can't come back to Fulton County unless you're here for court or to see Mr. Dobbs. That's the only reason you come back to Fulton County. Am I clear? Give me a thumbs up if I'm clear. Absolutely. All right. Don't run out of gas. Don't stop to get lunch. No drugs unless prescribed. No alcohol. No weapons. No replicas of weapons. You can't have any contact with anyone that's employed at the Twin Gates apartment. And also stay away from Twin Gates apartment, 25th Street, which should be fine because that's in Fulton County and you're not coming back here. So I'll do the 300, 100, 100, 100 through the sheriff's 10% program, and UJR, let's see. So we're going to make sure, make that level 2. Make it to the level 2. Through pre-trial. So 300, 100, 100, 100 through the sheriff's 10% at level 2. Best of luck to you, sir. You can leave the booth.
Are they all through the sheriff's 10%, Judge?
Yes, sir.
Thank you very much. May I please be excused?
Yes, sir. Have a good evening.
You too.
Do we have, let's see. No, we don't have Cobb yet. Let's see. Okay, what about Damian Arsenault? All right, Mr. Arsenault. All right, position 7, 22 CP 211273, 264 days without indictment. There's a $5,000 good bond as of March the 12th on theft by receiving stolen property. I guess pre-trials on it and they came off. Pre-trial.
Mr. Arsenault, 4 cycles, misdemeanor CWAC, sentence 2/7/24, 12 months, 24 SC 000521, ag assault on a law enforcement officer, theft by taking firearm during. 24 SC 00533, theft by taking, reckless driving, entering auto, criminal trespass. Maybe they changed it because there's a 533-01, theft by taking, reckless conduct, and obstruction. All assigned to Judge Edwards, nothing further.
All right. Go ahead, Ms. Gibson.
Judge, 1 second. Mr. Arsenault is 21 years old tomorrow. He has been in custody for quite some time, unindicted and on some pretty high bonds. He does have a good address at 3806 Makeover Court, which is the address on file with the court. He lives with his parents and 3 siblings. He has a twin brother and 2 younger siblings that he has been missing for quite some time. He works at Amazon and DHL. These are both jobs that he could get back because he was working at both of them for about 3 years prior to being arrested. He graduated from Grady High School, which is now known as Midtown High School. He has court next week, I believe, on the other cases, and he is looking to get those wrapped up with Miss Rondon. He also has completed the Chris 180 program, and when he is released, he will be reporting to the At Promise Center as part of the Chris 180 program. He will receive mentorship and continue in the Chris 180 program as an older adult. He goes to church at Limitless in Fayetteville with his family, and he also has one daughter who's 2 years old that he's looking to get back to. Judge, we would ask for, again, a considerably low bond in this case, not to exceed $500.
So where's he gonna live?
3806 Makeover Court, Judge, with his parents and his 3 siblings.
Is that in Fulton County?
That is in Fulton County.
All right, go ahead, Ms. Jackson.
Judge, the state would be opposed to a $500 bond in this case. It looks like Mr. Arsenault was originally accepted into diversion and failed to appear for his diversion. I didn't have a recent criminal history, so I thought maybe there was just some time that lapsed. But it sounds like based off pretrial summary of the history, during that time that he didn't report to diversion until he was picked up, it was because of a rendition of a lot of new charges, most of which seem to be violent in nature. The state is aware and acknowledges the amount of time that Mr. Mr. Arsenault has been incarcerated. However, based off of his history, the fact that he's 20 years old and has 4 cycles, all of which appear to be pretty violent, the state is going to request that the bond only be reduced to no less than $3,500.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 7994 Ella ELLA Lane in Fairburn, Georgia, and no contact with Raven RAYVEN Cullen CULLINS. And no further contact with Shadrack Dugan SHADRICK DUGAN. And sir, you're going to have a 24-hour curfew. Court, lawyer, medical, employment, but you have to supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. So you must continue with the Chris 180 program and participate in the, is it at Promise?
Yes, Judge, he completed the Chris 180 program. It's at Promise where he will report to for like mentorship.
All right, report to the at Promise program and participate in that. $3,000 good bond. Best of luck to you, sir.
And Judge, before we move on from that, my notes from Ms. Dorsey say that the victim is present in court. Can we just do a call to make sure that they weren't here?
For Cullen or Duggan?
Ms. Dorsey, do you know which one of the victims said they'd be here? I don't think I see either on the call.
They didn't show up. They just
Right.
they just wanted me to relay the message to the judge.
All right.
Okay, thank you.
Thank you. All right, you could lay the booth, sir. Do we have John Kevius Anderson? All right, position 10, Bostic, 23 CP 219715, 488 days without indictment. There is a $240,000 good bond as of March the 12th on ag assault, possession of a firearm during the commission of a felony, and reckless conduct. Wow.
Judge, 6 cycles in custody on no bond on 23 SC 189-724 capital offense for felony capital offense 6 counts criminal attempted a felony Don Woody 23 SC 191-797 burglary theft by taking a criminal trespass Don Woody, then 21 CR 005022G carrying a concealed weapon revolver under 18. He has a hold also in College Park. Nothing further.
All right, go ahead, Ms. Gibson.
Yes, Judge. Mr. Anderson is 20 years old. He's born and raised in Atlanta. His entire family and community is here. He lives with his aunt and cousins. I have that address. I just am not able to locate it in my notes at this point in time, but he does have a good address. It is in Fulton County. He, his mom and dad also live here. However, he does live with his aunt and cousins. His parents are in Atlanta. He has 4 sisters. He graduated from Life Christian Academy in 2022. He has a son who will be, actually, he turns 4 today, who lives with his mom. His son's birthday is today. And he was working at the McDonald's in Union City I believe he could get that job back as well as multiple other jobs. It has been a considerable amount of time that he's been in on this case and a considerable amount of time that he's not been indicted on this case. So I would ask that this bond be reduced not to exceed $75,000 aggregate.
All right, go ahead, Ms. Jackson.
Judge, the state would be highly opposed to reducing bond in any amount in this case, and because the defense has filed a motion for reconsideration, the judge does have the authority and the discretion to raise the bond in this case. The facts of this case are quite egregious, particularly when speaking of a 20-year-old man. The facts of the warrant allege that Mr. Anderson got into a verbal altercation with another 19-year-old boy, went inside of his house, grabbed a semi-automatic pistol, and got in the backseat of a car, riding around the apartment complex, shooting into the buildings. Multiple buildings were hit. Many buildings with children inside were hit and reported to the officers. The defendant was seen by witnesses actually firing the shots, and photo lineups were conducted with eyewitnesses to point out the fact that Mr. Anderson was the one in the backseat of the car firing the shots. Based off the criminal history, he has 6 cycles, 5 of which are in Fulton County. Again, Mr. Anderson is 20 years old. His criminal history started in 2021, and since then we have 6 cycles, almost all of which are open, with the exception of one that's under first offender right now. 2021, carrying a concealed weapon, having a gun under 18. It gets progressively more violent from there. 2023, aggravated assault, burglary. 2023, capital offenses with entering autos and tampering with evidence. As I stated, all but one of these cases are currently open. For that reason, Judge, the state would highly oppose reducing this bond. I did not catch how many days Mr. Anderson has been incarcerated, but I'm certain it's nowhere near the amount of time that the state had to indict this case now that Mr. Anderson does have a bond. For that reason, the state will request that the bond not be reduced, and if anything, the court raise the bond. As stated, it's currently set aggravated assault $125,000. The state would request that the court consider raising that to $200,000. Possession of a firearm or knife during the commission of a felony is currently set at $40,000. The state will request that the court consider raising that to $60,000. And as to reckless conduct, which was set at $75,000, a considerably high number for such a charge. But whatever court set this bond initially thought that it was extremely serious and should have an astronomically high number. And so we would ask that that stay the same.
All right. It looks like there's no bond, but there's some sort of August date in front of Judge Dunaway for the capital case. So there's no bond on that. So you're not getting out, sir, because there's no bond on that. All right. So we've got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with first name Shako, last name Huggins, Huggins, first name Shaneika, Huggins, Tanila, Tanilah, Bird, Zarecia, Drake, Zrecia, Drake, Amos Smith, and Alicia William.
And Your Honor, I did speak with 6 of those victims, and they did want me to report that they are afraid for their life, and they oppose bond at this time.
Okay, thank you so much. I'm sorry, I skipped right over you.
It's okay, and I also want to say that Felicia Mike, Myke, she is the property manager of a property on Godby Road. She asked that he stay far away from that property and away from her as well.
And what's her name?
Felicia, last name Myke.
Okay. Also add that Felicia, Felicia, last name Myke. No further contact with her. So stay.
Prior to setting the amount, I'm not sure what you're about to do, but I would just like to note that this was not a motion for bond reconsideration. It was a motion for bond reduction. So I don't believe that the court can increase the bond, as it is only a motion for bond reduction.
All right, so stay away from 2135 Godby Road, that entire apartment complex, no social media. no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. That also includes inside the jail, if you ever thought about, which I'm hopefully you haven't, any type of weapon there. All right. And if and when you get out, you're going to have a 24-hour curfew. Court, lawyer, and medical, the only reasons you can leave your home. And if you change addresses, sir, you need to send that address change into your lawyer so that she can file that. But you're going to live in Fulton County. So right now you can stay in Fulton County, but you're staying at your house. So I'll do 100,000, 30,000, and 50,000, 100, 30, and 50. Best of luck to you, sir. And Miss Dorsey Jones, you can obviously let him know that the capital case, there's no bond, so he can't get out anyway.
Yes,
And
ma'am.
so, real quick, I just wanted to ask, can we just put on there that the stay away for the victims be as reflected in the warrant? Because there were a couple of names that got a little jumbled up when we read them out, so if they'll just be spelled out the way they are in the warrant.
Okay, so you can put that and any victims spelled out in the warrant, Mr. Dukes.
Okay, Judge.
All right, let's see. Do we have Deshaun Atmore Maida? All right, so we got his position 8, Bostic 23 CP 215673, 561 days without indictment. Right now, there's a $45,000 good bond as of 3/12/2024 on battery, substantial physical harm, and aggravated battery. Wow.
His other case that was on the calendar was indicted 24 SC 003518 to Judge Edwards. There's a hold in Marietta for probation violation. 3 cycles out of New York. There's possession of contraband in a prison in 2016. There's a prior robbery in New York. He's on probation for aggravated assault, criminal damage to property, 11/27/23 for 5 years. 8 cycles in Georgia, FTA, and 23 on probation also for terrorist threats. 12/16/22, 1 year confinement, 2 years probation. Nothing further.
All right. Go ahead, Miss Gibson.
Yes, Judge. Mr. Atmore Metha is 26 years old. He is originally from New York. However, he's been in Atlanta since 2018. He has also been continuously incarcerated since December of 2021. He was in Cobb County and then was transferred January 2023 to Fulton County. He has been in for 561 days, and on the case before you, it has been 1,101 days since the actual incident. It took the state of Georgia quite some time to draw up warrants on this incident. And it's been a long time. And Mr. Atmore Metha is, I heard pretrial state his Marietta case for a probation hold. He is actually in Cobb County for that probation hold right now. He is not in Cobb County as a Fulton County inmate. He's there handling that probation hold with attorney Corey Bowles. He will be handling that under what we believe to be a time served sentence next week. And just to get into a little bit of Mr. Atmore Metha's life, his girlfriend, Sade Curtis, is on the Zoom call right now to support him. She and Mr. Atmore have been living at 2000 Monroe Place, apartment 710, Atlanta, Georgia, for the past 6 years. And he did a year at Morehouse where he studied business marketing. He also works at Hendricks Interior Design Firm. He was there for 3 years and he can get that job back. He knows the manager. Sade also works there. They have a daughter together, Amalia. She is 2 years old. Mr. Atmore has not yet been able to meet her in person, and he is looking forward to the day that he gets to meet his baby girl. So we are asking for a bond to be set in this case, since he's been in 561 days without indictment, not to exceed, I'm trying to see what it is right now. Judge, we would ask that say that again.
It's 45,000 right now.
Judge, we would ask for the bond in this case not to exceed $10,000. I forgot to mention that Mr. Atmore is from New York, but his family has all since basically moved to Georgia. So he has a good support system here, in addition to his girlfriend, his daughter. He has a brother in Buckhead, his mom lives in Smyrna, and another brother that lives in Douglasville. And everyone is ready for him to get out and become a part of their family again. So I would ask for the court to consider that and not set the bond beyond $10,000.
Can you contact Miss Dorsey Jones?
Yes, Your Honor. I did speak with the victim and she stated that she opposed bond at this time. She also stated that she's afraid for her safety and she's afraid for the safety of the community.
All right, go ahead, Miss Jackson.
Judge, I can't emphasize enough how much the state would oppose any type of decrease in the bond for Mr. Atmore Meta. I'm not sure if you've had a chance to review these warrants, but they are one of the most egregious that we've had on our calendar. The facts allege that Mr. Atmore Meta was a passenger in his girlfriend, Sade Curtis, who is on the line today. He was a passenger in her vehicle. Her vehicle suddenly stopped and her car was rear-ended. At that time, Mr. Atmore Meta jumped out of the passenger side of the vehicle, went up to the victim's car, opened the door, and beat her profusely, striking her over 20 times in the head, face, and chest. Her teeth were broken. She had a black eye, facial swelling, bodily bruising. Mr. Atmore Meta then fled on foot, and his girlfriend, Sade Curtis, went and made contact with the victim and then fled on foot as well. The only reason Mr. Atmore Meta was even caught to be charged for this crime is because his girlfriend then went to the police station to inquire about the vehicle that they had left behind. When she went to go inquire, the officer looked into Miss Sade Curtis's name and noticed that she had been a victim in countless domestic violence cases where Mr. Atmore Meta has pled guilty or been found guilty, and she has been the victim in all of them. A quick rendition of the history as stated by Madam Pretrial. There are multiple FTAs. Mr. Atmore Meta has violated almost every bond. He has violated multiple conditions, many of which were having contact with victims in his case, particularly Ms. Sade Curtis. 2020 aggravated assault, battery against a pregnant female, obstructing the 911 call. 2020 battery family violence. 2020 battery on an unborn victim. All of these with Ms. Sade Curtis as the victim. 2021 interference with government property, obstruction, multiple thefts. His bond was previously revoked because he failed to stay away from Ms. Curtis. He has New York violations, robberies, and keeping in mind, Mr. Atmore Meta is only 26 years old and was 23 at the time. I understood Ms. Gibson saying that he's been in jail for all these days, but she was straight to say that it's not all on this charge. He's been in Cobb County handling issues that were not even the ones that I just listed as a part of this history. For that reason, the state would be highly opposed to this being reduced. OCGA 17-6-1, Section B or Section 3 says that once a defendant has a conviction for a violent felony, then there's no conditions. It can be presumed that there are no conditions that this court could impose, no conditions that Your Honor could impose that could keep this community safe, that could keep a victim safe, that could stop a defendant from reoffending once released. And for that reason, and against Ms. Gibson's argument earlier that a motion for a bond reduction is any different than a motion for a bond reconsideration, the state will request that this be raised from 15,000 to 30,000 and to 60,000 from 30,000. Thank you.
All right, let's look at one thing here real quick. All this. Or do you know off the top of your head if any of these sentences says he's not supposed to have any contact with Miss Curtis?
I would imagine all of them, Judge.
I mean, post-sentencing, he's not supposed to have contact.
I'll be happy to check. There's a 2021 battery family violence, battery on an unborn child. Those are misdemeanors, so those would be 12 months. Even if they were consecutive, I don't believe that would still be in effect. But Ms. Curtis is on the line today if the court needs to hear from her.
All right, let me see. I got this one pulled up from Judge Wallace. I'm trying to see his, because he was sentenced in 2023.
Correct.
7 years to serve on the ag assault, 2 years of credit for time served, balance of 5 years on probation. criminal damage to property, 7 years to serve, 2 years credit for time served, balance of 5 years probated. The battery against the female and hindering, that's 12 months. All run concurrent, and let's see. 1 second. What is?
Judge, the disposition just says no further violent contact with Sade Curtis.
Thank you, because mine was taking a minute to pull up. I was like, they always decide they're going to work on Odyssey while we're having court. All right, let's see. No further contact with Nico Young, Niko Young. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. You're going to have an ankle monitor, if available, paid for by the county. Even if that ankle monitor is not available, sir, you're going to have a 24-hour curfew. And the absolute only reason you leave your house is court, meet with your lawyer, or to seek medical attention. That is the only reason that you leave your house, period. Let's see. What else I got in here? So it's been 561 days. So only thing I'm going to do here is it'll be 10,000 and 30,000. Best of luck to you, sir.
I wanted to say something, Your Honor.
I'm pretty sure Ms. Gibson don't want you to say anything, but Ms. Gibson. Hold on. Ms. Gibson, what do you think?
Sir Atmore, I would advise
It's nothing pertaining to my case. No details about my case.
Okay.
88 Jackson mentioned that I had a conviction out of New York for an armed robbery, which I got a youthful offender status for, so she was never even supposed to mention what my conviction was. I have a youthful offender status, which is sealed, which every time I ever had a hearing, a bond hearing, anything, they never mentioned it. They always mentioned that it was a youthful offender status. And that kind of violated my whole youthful offender status by you even mentioning that I had an armed robbery.
Well, sir, believe it or not, that doesn't even really matter to me. What matters to me is all the cases you have against Ms. Curtis, and obviously this where you put this lady in extreme danger. So,
I didn't put nobody in extreme danger. Those are allegations.
Mr. Atmore.
We're just gonna go ahead and mute him. All right, you can leave the booth, sir. Best of luck to you, Ms. Gibson. I'll include that in my email.
Judge, I just want to clarify, you did not reduce the bond in that case, correct? You maintained it?
No, I gave him 10,000 and 30,000, so it's down to 40.
Okay, I thought it was at 40, but I must have misheard.
It was at 45.
Okay.
Okay. 15 and 30. Thank you, Ms. Gibson. Pass it on to your to Ms. Rondon and stuff. You know, anybody over 90 days, you guys get back on here.
Okay, I sure will. And that concludes my business. May I be excused?
Yes, ma'am. Have a good evening.
Thank you. You too.
All right. The last case we have is Ms. Sofrossi's case. So it is Wayne Mulder, Moulder, position 3, 24 PI 003101, 96 days without indictment. There was a consent bond May 24th of $20,000 on armed robbery. Wow.
Mr. Mulder, 5 cycles, open case 23 SC 189864, ag assault, probation. Sentence 3/12/24, 2 years, then open case 24 PI 003684, false statement, false report of a crime. Nothing further.
All right. Go ahead, Ms. Sofrossi.
Thank you, Judge. Mr. Mulder is 20 years old. We do have a good address for him. Lithonia. I never pronounce it right. I think it's Lithonia, Georgia. And he's had the address for 7 years. Lifelong resident. Whole family is here. Tragically, his mom just passed away in April, Judge. I'm sorry, not in April, in June. His mom just passed away in June, and then his godmother was her best friend, and so kind of like a mother figure, auntie figure to him. She's now in the hospital. She, as well as Mr. Mulder's sister, is trying to come up with the money, but they cannot afford the $20,000 bond, Judge. But he has family, he has a support system here. He was enrolled in the CAB GED program in Stockbridge. This is at Stockbridge. He was employed at Amazon at the time of his arrest, but he knows the manager, and so he thinks he can get his job back at Amazon. He worked in the warehouse. Judge, we do have some MH issues here. I do want to point out the case that there's the probation, that's the first offender case. He has to deal with that as well. The other case that was served, the false statement case, they served that case after this case. So it's not a situation where he was out on this case and picked that up. They just served that case later, Judge. And
Okay.
that case is not holding him. The only thing that's holding him right now is this case. It's my understanding, the one before you. Judge, also a little bit about him while he's been in the jail is there's been multiple jail. They've had to move him, not because he's the aggressor, but because he's getting attacked in the jail. Most recently, he was stabbed and assaulted in the jail, Judge. I think this is kind of contributing to also his mental health issues that I sent out to you. I didn't want it to get out to everyone, otherwise I would have included Miss Jackson, but since it's cat's out of the bag, Judge, he's on suicide watch. That's why he's not here today. He indicated to me that he's afraid he's going to kill himself. And so that is why we have him on suicide watch. And I don't appreciate the head shaking to that either, ADA Jackson. It's a serious matter.
Stick to your legal argument, please. Thank you.
So, Judge, because of that, that's why he's not here before you. He's a young kid. We waived prelim. We didn't even have prelim. We waived for that bond. He can't make the bond, Judge. We've been here this long. I'm asking you to take it down to $10,000. He's gonna have his sister, who is an adult, and he's gonna have his godmother when she comes out of the hospital, God willing. But he has other family here that's extended family. Those are just the prime people who would be able to actually pay and support him. But he has that here, Judge. So I'm asking you to bring it down to 10, please, so we don't have another death in the Fulton County Jail.
All right. Go ahead. Any contact with the victim, Miss Dorsey Jones?
Yes, they are asking right now that the bond be denied, Judge, for the safety of themselves and the community.
All right. Go ahead, Miss Jackson.
Judge, it does appear that Mr. Mulder is 19 years old. He's picked up a pretty extensive criminal history in the last 2 years since we started counting his adult history. He's got a 2022 terroristic threat, which is a felony. As Ms. Safarasi stated, he's got a 2022 aggravated assault and robbery that was sentenced under first offender, I believe, just earlier this year. He's also got a 2023 terroristic threat that's been charged as a misdemeanor at this time. We do believe that Mr. Mulder is an extreme danger to this community, and he is likely to reoffend based off of his history. The state acknowledges the issues that Ms. Safarasi just stated about potential MH issues and things that he's dealing with at the jail. However, quite frankly, the issues at the jail are not a persuasive argument as to why he should be released or why he would have preference over anybody else on this calendar who is incarcerated at the Fulton County Jail. If Ms. Safarasi has some plans or some next steps on some MH treatment that we can get for Mr. Mulder, the state would be more inclined to work with her on getting him released to that treatment. As Your Honor can see from Odyssey, we just did a consent bond on this where Ms. Safarasi or whoever was representing him at the time agreed to the $20,000. So it's not like the state has been unreasonable in trying to get him a bond. And if I remember correctly, the preliminary hearing was waived so that Mr. Mulder could get a consent to a bond. So again, it appears that the defense and the state are working very well together to try to get this case moved along. But as far as just reducing the bond willy-nilly so that he can be released, the state opposes that. He's very dangerous. He's a danger to this community. He's likely to reoffend. He has multiple open cases. All of his cases are violent. And so the state would request that this stay at $20,000.
All right.
Judge, all his cases are not violent. False statements is not a violent charge. Even terroristic threats is not a violent charge if his charge is a misdemeanor. So I would object to these calling those violent. He has one open case that's violent before you, and the one conviction he's under first offender for. And he'll deal with the first offender probation when we go up to probation on that one.
Is that all set for hearing?
I don't Breonna Bray represents the probation judge, so I don't know, but I will get him on a calendar if he's not.
Okay. So let's see. No further contact with Jelani, Jelani Tate, Tate. Stay away from 2471 Old National Parkway in Atlanta, Georgia. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. If they put him on medication, Miss Safarasi, send me that order for the 30-day if he happens to be on medication at some point in time.
Okay, Judge.
That's
As of
what-
right now, I don't believe he's on any meds, but as you know, he's with the doctors right now.
So if they put him on some, you can send an order to release him with a 30-day supply, and I'll be glad to sign that. Let's see, no drugs, no alcohol, no weapons, no replicas of weapons. He's gonna stay out of Fulton County. The only reason he can come back to Fulton County is court, lawyer. If he has further MH follow-up with Grady, he can come back for that. Any MH follow-up unless they, have him somewhere else. So that's the only reason he comes back to Fulton County. And let's see, and he'll
Yeah,
go.
that shouldn't be an issue because he doesn't live here. So
Yeah, okay, and he'll have a 24-hour curfew, court, lawyer, medical. Employment, but he has to supply the name of his employer, proof of employment schedule, in the exact location he'll be working. So, Ms. Frosty, I'll reduce this to 15. You could reach out to whomever and, they could see what they could do. I don't know if it'll,
reach out for what, Judge?
to Mr. Royals, Mr. Hutchinson, I don't know.
I will, Judge. I have better luck with other
So,
ideas.
with the, all right, yeah, so that'd be $15,000 good bond. And Ms. Safrazi, I'm going to email everybody with the number of days, like I always email the state. Would you like for you to put the caveat about your client in parentheses for the higher ups at the state?
I don't think they'll do anything about it, Judge, to be perfectly honest with you. So I prefer not to because I don't want them to use that against him.
Okay, I got you. Okay. All right. Thank y'all. Have a good evening. Looks like that's it.
Hey, Ms. Paparazzi, do you have a phone number? Can you send that to me in the chat, or can we talk offline?
Sure. I'll send you my cell phone number. I'll email you my cell phone number right now.
I don't even
Okay.
have it, Miss Jackson. Good for you.
I'll send it over.
Thank you guys. Have a good night.
Thank you,
Have
Judge.
a good evening. Yeah.
Okay.
Now,
Next on as well.
okay. All right. So, first we need, so Mr. Julio Galvan Ramirez. You got him on the screen?
Julio Galván Ramírez, levante la mano.
Booth 3, I guess that's not him. We got 2 in Cobb. That must be Mr. Wait, where's Ramirez? Ramirez and Alfred. Alfredo, where you at, Alfredo? All right, Mr.
here.
All right, so Ms. Chavez, you want to raise your right hand, you swear affirm you'll translate from English to Spanish, Spanish to English to the best of your knowledge, skills, and abilities.
I do, Your Honor.
And you have the style of the case, Ms. Chavez?
No, Your Honor.
Okay, well, I'll send you a picture too if you'd like. But
Okay.
position 1, Murray. Ms. Murray, anybody cover for Ms. Murray?
I'll reach out for her. I don't know if anyone is covering, but I'll reach out to her. So sorry.
No, outstanding.
Oh
That
wait,
way-
I see Parisa holding her hand up in courtroom 3.
Oh, unmute yourself, Ms. Salfarasi. I just promised Ms. Chavez that she came on here, I would get her in and out.
Judge, Vogel had to go put someone back, so they took my client to back, and we have to wait for Vogel to come back with him.
Okay, yeah, so I think I thought you knew something about that. Mr. Morrell said he knew where Miss Murray is. I don't see her on here.
I can give her a call, Judge.
All right, thank you. Stand by, Ms. Chavez. I promise I am not a tattletailer. So let's see, AC, so it's Shelby Marshall. We got Miss Guest here.
Yes, Sean, I apologize about that.
Okay, well, I guess she's got to go get. Thought she had Shelby Marshall already. Well, and Miss Lewis is coming in too, so we'll do that. All right, Cobb. So are you Devin Ravello? Wave your hand if I call your name, gentlemen. Wave your hand. Or if you are Mr. Ravello.
Señor Rovello, levante la mano. Señor Rovello. Is that Señor Rovello?
We're gonna find out if Miss Murray gets here real quick. All right, Geronte
Ravello does
Dupri.
not need a Spanish interpreter.
Yeah,
so.
no, he doesn't. Yeah, we'll wait for Miss
Maybe 3
Murray.
of them, 3.
Yeah, Miss Chavez, we're gonna wait for Ms. Murray, they're reaching out to her. All right, Devin Ravello. Mr. Ravello. No, not that one. Yep, Ravello. Dupri. Mr. Dupri. You Dupri?
Yes, he's in booth 3.
That is Dupri?
Yes, Your Honor.
Thank you. It's been a long day today. Mr. Dupri, one of your cases was indicted. Mr. Morrell may have already told you that, but it was indicted, okay? So, and it was the case in with a couple of entering autos, criminal trespass, theft by taking, okay? It has like 1, 2, 3, 4 charges or so. This is position 6. 24 PI 000394, Geronte Dupri. 205 days without indictment right now. As of June 26, you got a $4,250 good bond on entering auto and criminal damage to property 2nd degree. Wow.
This defendant has 12 arrest cycles, received first offender treatment in 2020 for 3 counts of entering auto. That was sealed in 2024. There is an indicted case with DeKalb County for 2 counts of entering auto, and it was indicted in March of this year. No disposition was listed. An FTA in 2022, an FTA in 2023, and there appears to be a hold with Gwinnett from January of this year for a fraud case. Nothing further.
Go ahead, Mr. Morrell.
I'm sorry, if I can inquire, Ms. Washington, did you say a fraud case out of Gwinnett County?
Yes. The warrant date is January 19th of 2024.
Jesus. Okay. I have spoken with Mr. Brad Malkin about these 2 cases, Your Honor. I believe we have reached a consent on the entering auto is going to go to I asked him if he's okay with it going to 2,000 and then the 250 to a UJR. Brad, all of his cases, his indicted cases are between me and you, so we're probably going to work out a global. We understand it may include going down the road. Just speaking to your last sentiment that you wrote, just so you know.
Yes.
Mr. Malcolm?
Yes.
Right. Is he going to live in Fulton County, Mr. Morrell?
Yeah. Yes, he's going to live in Fulton County, but I doubt he's going to get out from custody right now.
Okay. All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Sean, S-E-A-N, Mincey, M-I-N-C-E-Y, Lamarcus, L-A-M-A-R-C-U-S, Bird, or Christopher. Last name is H-I-D-A-L-G-O, and no further contact with your co-defendant. It's A-J-A Dozier, D-O-Z-I-E-R. Stay away from 915 Glenwood Avenue. So don't go anywhere around there. And once you get out of jail, there's probably not an anchor bond that's going to be available because of the budget or whatever, but you're still going to have a 24-hour curfew. The only reason you leave your house is court, lawyer, medical, and employment. And if you change your address, sir, the onus is on you to let Mr. Morrell know so that Mr. Morrell can change your address in Odyssey so the clerk and the court will have your address. All right, so that's the only reason you could leave the house, but you got to let Mr. Morrell and pretrial, because you're going to be in pretrial, know exactly where you're working. So it's 2,000 on count 1, entering auto, and UJR through pretrial. Level 2. Best of luck to you, sir. And pretrial, Miss Robinson, if you can note on there that there's a hold in Gwinnett, okay. So it may take, it may be a little while before he can actually report to pretrial. Thank you much. All right, now we got Ms. Murray.
Yeah, sorry, Your Honor.
That's okay. I made a promise to Miss Chavez. Now you got Miss Chavez, man. No, okay. All right, this is position 1. I think it's the add-on 24 PI 003289. It's Julio Galvin Ramirez. 93 days without indictment. It's burglary in the 1st degree, criminal damage to property in the 2nd degree, $5,000 good bond on 510. He'd had a previous bond, Ms. Chavez, and it was I think it was through pretrial, but they came off of it.
No, I missed all that information. I'm so sorry.
All right. Where else you need me to start? I'm gonna send you a picture too.
Okay. I went to the number and that's as far as I got.
So he had a $5,000 good bond. as of May the 10th. In June, I think they had changed it to a pretrial bond, but they came off of that.
Ok. Señor, usted tenía una fianza de $5,000 en mayo 10, pero después iba a pasar a pretrial, se la quitaron.
So it's burglary in the first degree, criminal damage to property. It's been in 93 days.
Usted ha estado en la cárcel por 93 días. Usted tenía una entrada ilegal a una propiedad de primer grado y también daño criminal a la propiedad de segundo grado.
All right, Bostic 2.0. Wow. And make sure you think about Ms. Chavez has to interpret.
Antecedentes.
Ah, there you go. With some power right there.
It's 5 arrest cycles, a 2002 misdemeanor conviction for a DUI, no felony convictions listed.
Tiene 5 ciclos de arresto, tiene un delito menor en el 2002 por conducir bajo la influencia y no hay delitos mayores.
Go ahead, Ms. Murray.
Thank you, Your Honor. Mr. Galvin Ramirez is 44 years old.
El señor Galvin Ramírez tiene 44 años.
He has lived in Georgia for 24 years, and he does have an address where he can reside if released on bond.
Él ha vivido en Georgia por 24 años y tiene una dirección en Georgia donde él vive.
He would be living with his brother Miguel,
Va a vivir con su hermano Miguel
and also 2 of his 5 children.
y 2 de sus hijos, de sus 5 hijos.
He is a high school.
County, Ms. Murray?
It's in Roswell. Is that?
Yeah, it is. Okay, sorry.
La dirección es en Roswell.
He graduated high school, and he also has been employed as a commercial roofing contractor for the last 10+ years.
Él ha terminado la preparatoria o el bachillerato y él ha trabajado por más de 10 años poniendo techos.
And he has a very limited arrest history.
Y él tiene antecedentes penales bastante limitados.
Seeing as it's been 93 days and the state has not yet indicted this case,
Ya que han pasado 93 días y todavía no le han hecho la acusación formal,
we are asking for $50 on count 1 and $50 on count 2.
pedimos que le ponga una fianza de $50 por cargo 1 y $50 cargo 2.
So there's already 5 on burglary in the first, and there's UJR with wrap services on count 2.
O sea que ya teníamos una fianza de $5,000 para el cargo 1 y una bajo palabra para el cargo 2.
Apologies, Your Honor. Yes, that's right. So we would ask for 50 on the burglary, and then the UJR rep services could remain.
Correcto, su señoría, me quiero disculpar. Sí, estamos diciendo que le den una fianza de $50 por el primer cargo y para el segundo cargo salida bajo palabra.
All right. Go ahead, Mr. Malkin.
Señor
Thank you, Your
Malcolm,
Honor.
fiscal.
The state would request $3,000 on the burglary and the UJR rap on the criminal damage.
La fiscalía está pidiendo que se le dé una fianza de $3,000 para el primer cargo y para el segundo salida bajo palabra.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons.
No puede utilizar drogas solo si son prescritas por un médico, no puede beber alcohol, no puede portar armas ni tampoco copias de armas o armas de juguetes.
Stay away from Roswell Creek Apartments.
Tiene que mantenerse alejado de Roswell Creek Apartments.
That's at 814 Roswell Creek Lane.
Eso está en 814 Roswell Creek Lane.
All right, so I'll do 3,000 on count 1, and I'll keep it at UJR wrap services, but we can do it under the 3,000. We'll do it under the sheriff's 10% program.
Ok, entonces le voy a dar una fianza de $3,000 para el primer cargo y bajo palabra para el segundo cargo, pero los $3,000 va a ser a través del sheriff, que solo se paga el 10%.
Hey, Bostic 2.0, when they do UJR wrap service, is it level 1?
I believe so.
Okay, so that'll be under the 10% program. It's through pretrial, and it's level 1.
La salida bajo palabra va a ser a través de pretrial nivel 1.
Sir, you just need to make sure that you report to pretrial when you get out, okay?
Señor, tiene que asegurarse que cuando usted sale, tiene que reportarse a pretrial.
Thank you, sir. Thank you, Alfreda.
Gracias.
And thank you, Your Honor. May I be excused?
Yes, ma'am, Miss Murray. Thank you so much for showing up. Thanks, Alfreda. Have a good evening. All right, so now we have Madam ASL interpreter.
Okay.
So, Ms. Clark, I hope that it doesn't hurt you translating with my accent. It probably doesn't go so well through.
That's not a problem.
But when you do it, make sure you do it with an accent so that.
That might be a problem.
Okay. All right. Ms. Safrazi, you hear us? Oh, you want to unmute Miss? Okay, you are.
Also don't know who I'm interpreting for, where they are.
So if you look, do you have it on speaker
Gallery.
view? Oh, you see her? Okay, okay. So this is position 1. It is 24.
I apologize. I'm looking at courtroom number 3.
Oh, yeah, you are.
Okay.
Okay, I'm sorry. Yeah. Will you raise your right hand, Madam Interpreter? You swear or affirm you'll translate from, well, I don't know how to, from
American
the spoken English language into ASL and ASL into American spoken language to the best of your knowledge, skills, and abilities.
Yes.
All right. Thank you, Ms. Chavez.
Am I done, Your Honor?
Yes, ma'am. Send me your thing. I'll sign it right now.
Okay.
Have a good one. All right. This is 24 PI 003063. Miguel Ortiz, 100 days without indictment. As of May the 8th, there's a $40,000 consent bond. And we've got 1, 2, 3, 4 count for CWAC, like crimes against women and children is what CWAC stands for. Charges.
I am waiving sound.
All right. And Bostic 2.0, if there's any other CWAC, you don't have to, you can just say it's a CWAC charge, okay? All right. Wow.
This is the defendant's only arrest. Nothing further.
All right. Ms. Safarasi.
Yes, Judge, thank you. I would also just point out, Judge, that Mr. Ortiz's mom and sister are actually on the Zoom in support of him, and they've come to every court date. His mom lives in New York City. Our plan is, and this is something that we had run by Judge Brooks with our consent bond, is that she wants to take him back to New York. So he was living here in Georgia. He's been in Georgia for 10 years. He's married to the complaining witness's mom. It's the complaining witness is his stepdaughter. So he's married to her mom. That's why they're living here. He also has a 4-year-old daughter here in Georgia, Judge. He has a condition where he's allowed supervised visits with her. That's what Judge Brooks allowed. We are asking for the same conditions that Judge Brooks already instilled. I think they're pretty tough conditions already. The only modification is that his mom has moved from the address that is listed. We had listed a specific address. I have the new address. She just recently moved. She is in New York City. His mom is planning on coming to Georgia to post the bond for him, take him back to New York City and supervise him. And then whenever he needs to come back to court, she will bring him back to court, Judge. So there is a plan in action for that. We also are asking for that supervised contact with his daughter. She is not a subject. She is not an issue at this case. My understanding is that his mom has had communications with his wife, and they don't want contact, and that's fine. But the mom is the one that coordinates that third-party contact for their daughter, the mutual shared daughter. Mr. Ortiz is 31 years old. I will provide a file change of address of this new address, but it is in Yonkers, New York. Like I said, Judge, he's been here for 10 years. He does have family in the area, but due to the situation, we are going to go to New York, so everyone's separated at this moment. At the time of his arrest, he was employed, Judge. We also have a lot of medical conditions for Mr. Ortiz. As you can tell, Judge, he's deaf. That's why we have the ASL interpreter here in front of you. He's been deaf all of his life, Judge. When he was born with, he had seizures, he had a seizure disorder. That actually, no, that wasn't when he was born. It was after his jaw was broken. He developed a very severe seizure disorder, so he has that. He also has asthma and a breathing issue. He is on medication for these. When he was born premature. And so when he was born, he was actually born deaf, Judge. And he was only 5 pounds. So he was a very young child. We have health issues here. First time he's been arrested, Judge, for anything. But also note that he's been compliant with everything. He told the officers, he made confessions to the officers, Judge. At this point, we're just trying to resolve this case that's best for everyone. Because he has no history, I don't think he's likely to reoffend. And because we have those special conditions in place to prevent him from having, any unsupervised visits with any children, I don't see any issues with this being reoffending. Again, because no history, no failures to appear, or any issues in that point of view. There's no likelihood to intimidate witnesses. I would say because he cooperated, he's made confessions. This is not about changing the story. It's really about just getting the state to resolve it. He's been in 100 days. We did do that consent bond, Judge. He cannot make it. His mom cannot make it. We are asking for a bond not to exceed $25,000 with those same conditions that Judge Brooks put in place for him because it's been working for everyone. Just the modification of this new address that I have for your knowledge. Thank you.
All right, Mr. Peoples.
Yes, Judge, good evening again. Your Honor, the state would ask that, addressing first the issue of the indictment. I worked on the indictment myself today. It's going to be being presented to the grand jury tomorrow morning. So as we work towards, as defense has just said, work towards resolving this case. Yes, Mr. Ortiz did make confessions as well. And there was, there was a consent bond. I believe it's a $40,000 good bond. And the state believes that's an appropriate amount for these charges. Additionally, Your Honor, the bond was consented to. I had on my notes May 28th.
Yes.
And I don't believe there's been any material change of circumstances. I mean, as defense has just stated that Mr. Ortiz is looking to resolve his case, that's going to be happening very soon, as it'll be indicted tomorrow. But the state believes that there's been no substantial change of circumstances. The bond amount was set and consented to, and we believe that it's an appropriate amount as well.
Judge, I would just add because it gets indicted tomorrow does not mean it's getting resolved tomorrow. It's a long process from the indictment to the resolution of this case.
Okay. All right, so no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons.
That's correct, Your Honor. And I'll note that the victim at the time was 13. And this is, I believe, $40,000 is appropriate, Your Honor.
All right, so I got no social media, no internet access. So, Ms. Safrasi, are you saying that, are there children or minor children where he's going to be living?
I don't believe so, Judge. His daughter will be here. His stepdaughter will be here in Georgia. He will be living with his mother. Like he will always be under supervision from that point of view. Judge, just one caveat though, the no internet access, he speaks with his daughter on FaceTime. Is that allowed? Can he still do that video visits with supervision?
Is mom going to be there while he's speaking to her?
Yes, Judge. That's already what's instructed. We went through a very detailed with Judge Brooks. That's why if you look at the order, it's pretty detailed with his conditions.
Okay, so he can have internet access only to speak with his daughter?
Okay. That's it. Just because he won't be coming to Georgia so frequently, and because he can't talk on the phone like an average person, Judge, they would need to have some type of video chat.
Sure.
To be able to have.
I get it. Stay away from 4307 Caliber Creek Parkway in Roswell. stay out of Fulton County unless you're here for court or to see your lawyer. That's the only reason you darken the doors of Fulton County. No further contact with Camilla. Last name is Orozco. And no further contact with Jessica. Last name Orozco hyphen OCAMPO. All right. So let me get rid of this. The software will supply updated address for the Yonkers, New York, but you have to keep the address where you're living with your mother updated through Miss Alfarasi so that she can file a change of address if needed. So you're allowed to travel to New York and live with your mother at the address that Miss Alfarasi will supply. I'm going to say no further contact with anyone under the 18 years of age, with the exception of his daughter, and that has to be supervised by his mother. His mother's name is IBETT. Last name is AQUIN. Is there an O on the end of that, Miss Alfarasi? Yes. AQUINO. So she has to supervise even his FaceTime chats and visits if she comes there, but he can't be around anyone else that's under the age of 18. All right.
Can that be extended with the caveat of the supervision with his mother for families? Like, because I know his brother does have, I know his brother lives in New York and has children, just with the exception that they're always supervision. There's always going to be supervision with an adult. Either his mom or his brother or someone. Just so they can go to family.
He could have, what do you think, Mr. Peoples?
Your Honor, I would ask that I would ask that the caveat that the court has already said that he have supervised contact with his own child is appropriate and sufficient.
Okay, we'll just leave it at that, and hopefully y'all will take care of it really quickly. And if y'all work out anything and y'all need me to sign it, y'all can send it to me. All right. Make sure I'm trying to read the other order. Okay, 28th May. Let's see. I'm going to do this. Go ahead.
Can you just also, just so it's clear that he has authority to leave the state of Georgia to, so he can live in New York and come back to court, just so that's clear that he can travel to New York?
Well, I'm going to do it. Okay. I mean, I said, yeah, he can go and live with New York with his mother at the address that you'll supply. I'm going to make this a 10% through the sheriff's program. And his check-ins, though, Bostic 2.0 will note on there probably needs to be video because obviously he needs to see them and however he needs to communicate with his mother to help. That way, they see him or something and he can check in. I don't think it's that often, Miss Alfarasi. So I will do, let's see. All right, I'm only going to reduce it very little because I'm adding the condition. So it'll be through the 10% program at level 1. He can, and like I said, check in via video so that he can meet with his pretrial officer. So I got 29, 4, and 4. 29, 4, and 4. It'll be through that 10% program.
Does it have to be through the 10% program?
Can you make the good bond? Do you want me to leave it at the good bond?
I've had Judge Brooks do either or. Can we just make this one either or?
Oh, she didn't do it either or, but yeah, we can do it. It can be through a good bond or the sheriff's program at level 1.
Okay, thank you, Judge.
All right, that's it. Best of luck to you, sir.
Well, I just got.
I'll mute it if you want me to. So, Madam Interpreter, thank you so much. As soon as they get me your invoice, I'll sign it. But let me see how you sign.
Sign what?
When I said how'd you sign that?
Pre-trial.
You got drag it out. All right. Thank you, Madam Interpreter. Like I said, if you send the invoice to them, they'll get it to me as soon as possible. Okay.
Thank you, Your Honor.
All right.
Thank you. That concludes my business. The will may be excused.
Yes, sir. Have a good evening. So
Thank you,
now
Judge.
do I have Who else is, we got somebody at ACDC. That's Shelby Marshall, ACDC. Shelby Marshall, step on up to the chair, Shelby. All right, so we got position 4, 24 PI 003 362, 90 days without indictment, a $15,000 good bond as of June the 4th, 2024 for aggravated assault. Rah.
There are 24 arrest cycles, a 2003 misdemeanor conviction for simple battery and battery family violence, a 2006 felony conviction for theft by taking, a 2006 felony conviction for willful obstruction, a 2007 arrest for simple assault, which was dismissed. In 2010, there was a felony conviction for a terroristic threat. In 2011, there was a felony conviction for aggravated assault, as well as a felony conviction for aggravated assault in 2019, and one FTA in 2022. Nothing further.
All right, go ahead, Ms. Guest.
Yes, Your Honor. Miss Shelby is 44 years old, and she has been a lifelong resident of the Atlanta area. She was renting a apartment prior to being incarcerated, having in the same apartment, from what I understand, since about 2022. However, since she's been incarcerated, she has lost that apartment. But it is my understanding that she would have the opportunity to reside with family upon her release. But that is in Fulton County, Your Honor. So we would ask that any conditions that's placed on her bond that would prohibit her from being able to return back to Fulton County is lifted. Prior to being incarcerated, she was receiving Social Security disability because currently Ms. Marshall does suffer from congestive heart failure. So we are extremely concerned about her care while she's in custody at with Fulton County. But she is a housekeeper by trade. She also received her cosmetology license from Atlanta Technical Institution. She does have 6 children. They range in the ages of 6 to 25 years old, all whom reside in the Atlanta area. There are some MH issues that we are concerned about. So we would ask that if the court is inclined to reduce the bond, which is what we're requesting today, that Ms. Marshall be able to be released with whatever medications that she is currently taking while at the jail. Also on the call today, we do have her PAD social worker, which we would like the opportunity to allow her social worker to speak to some of the services that or a service plan that we have together for Ms. Marshall upon her release, Your Honor. And the court is inclined to hear from Ms. Marshall, so caseworker with PAD.
All right, if the representative from PAD will turn your camera on, raise your right hand, take yourself off mute. How you doing? All right, you swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth.
Okay, so I work for PAD. So with Shelby Marshall, she's been in our program for about a year or two. She's been working with us, and she has had obviously her struggles. Our plan with her when she does get out is she does have family she can live with, but we also have other treatment programs in place that can provide her extra support. And those will focus on her substance abuse and everything else and we'll give her better health care options as well. So, yeah.
All right, go ahead, Mr. Malcolm.
Thank you, Your Honor. Thank you, Ms. Heibel, for showing up. Your Honor, this defendant has a violent history, as we've heard from pretrial Bostic 2.0, and this is a violent case. The state is concerned that there's a significant likelihood to reoffend, danger to the community, danger to victims, and the state is requesting that the bond remain the same.
All right.
And I apologize, Your Honor. I didn't get the opportunity to actually have our request. I'm asking that the bond be reduced to $4,000, seeing as though Ms. Marshall wouldn't be able to make any contribution towards bond at the amount that it is. Now that the bail project is back operating, we were hoping to be able to get the bond reduced low enough to allow her to be able to utilize the services of the bail project. And just so the court is aware, based off the warrant, this is isolated incident, meaning that Miss Marshall does not know the alleged victim. I would ask whether or not the state has had the opportunity to speak to the alleged victim, but Ms. Marshall is prepared to present defenses in regards to her case once given the opportunity, Your Honor. So I do not believe specifically as it pertains to this case that Mrs. Marshall poses any significant threat to the alleged victim listed in the warrant. So we would ask that the court also takes that into consideration when placing the bond, we're considering a bond reduction.
I don't know if that is favorable to her that she goes around assaulting strangers versus people she knows.
Ms. Guest, did you say she's going to live in Fulton?
Yes, Your Honor, that is correct.
All right. All right.
And I apologize. And as far as it being an isolated incident, I do believe that this was an altercation between an individual where in Ms. Shelby's defense, it was a self-defense element that, again, Ms. Shelby would have the opportunity to present.
We're going to object to a probable cause argument, Your Honor. This is not the time or place.
Not a probable cause argument so much as just going to the fact that, as the state pointed out, this is an isolated incident. It would, against an alleged stranger, that it would not really go to her likelihood to reoffend or dangerous to the community. Just trying to express to the court that it isn't necessarily an isolated incident, as the state wanted to point out, because I was at the probable cause hearing. And so then I do believe I do know slightly more about the facts of the case than what is in the warrant and what the state may have access to at this time, especially if they have not had the opportunity to actually speak to their alleged victim, Your Honor.
All right. So, has there been any contact with the victim, Ms. Rhodes?
No, Your Honor.
Okay. All right. So no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. That includes a broomstick. No further contact with Lamon, Lamon, Yancey, Yancey. Stay away from 1801 DeLoe Drive Southwest in Atlanta, Georgia. Ma'am, you have a curfew. You got to stay at home except for court, lawyer, medical, and employment. Be able to supply the name of your employer, proof of employment schedule, and the exact location you'll be working. I'll make it a $12,000. Do you want the sheriff's 10%?
If there's an option to do either or, Your Honor, that would probably work better in Ms. Marshall's favor.
Okay, so we'll do either or, 12,000, either or, Miss Robinson, and it'll be at level 2. Thank you, ma'am. Best of luck to you. Thank you, ACDC.
And Your Honor, that concludes my matters with the court. May I be excused?
Yes, ma'am. Have a good evening. Good weekend.
Thank you. You do the same.
All right, Mr. Showalter, position 7, Devin Ravello. Like move your head or something, Mr. Ravello, so we'll know it's you. There we go. Position 7, 23 CP 222677, Devin Ravello. It's got a $15,000 good bond as of 6/5 on receipt, possession, transport of a firearm by a convicted felon or felony first offender, cruelty in the third, battery, family violence, first degree, and cruelty in the third. And I'm sorry, Mr. Showalter, for some reason I missed putting how many days, if you happen to know.
251 according to Odyssey.
251?
Yes.
251 days of indictment. Go ahead, Mr. Showalter.
Okay, so Devin Ravello is 28 years old. If released, he would be living at 1618 Line Circle, Decatur, Georgia. He has been in the Metro Atlanta area for over 15 years. He was previously working at Langston Tree Service Associates. That is a business run by one of his family members, an uncle. He's been doing that for 5 years. So it is something that he can return to. Let's see. All right. So this is a case that he is looking to get resolved. I'll note that there was another case that he has that was indicted recently. And so I do find it always, I don't know how the state does these things, but it is odd to me when they have 2 cases close together in time, they indict the one but not the other. That's what happened here. And so while we have the state here, the defendant is looking to resolve the case, and so we can.
So Mr. Showalter, is the other case holding him in too, or is it indicted?
Yeah, it is.
Okay.
Yes. So on this particular case we have here today, he's got $15,000 bond. On count one, I would like it reduced to $3,000, and count three to $2,000. Counts 2 and 4 can remain at 1,000 or be reduced to 500 each.
All right. Go ahead, Mr. Malkin.
I believe that he's in on a bond surrender on these charges. And the state believes that he does pose a significant danger to the victims and witnesses in this case, a danger to the community, as well as a danger to reoffend. And the state is requesting that the bond remain the same.
All right. So it's no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Mia, M-I-A, Pitchford, P-I-T-C-H-F-O-R-D. And let's see, first name S-A-I-Y-A Wilson, or Alexis Smith. Stay away from 601 Summit Place in Sandy Springs, Georgia. Actually, you got to stay out of Fulton County, period, sir. The only reason you darken the doors of Fulton County is for court or to see your lawyer, period. Don't stop for gas. Don't do anything. Watch out when you're on 285. Some of that hits Fulton County, and don't get a flat tire. All right? You're going to have a 24-hour curfew, court, lawyer, medical only. All right. So I'll do 5, 1, 2, and 1. 5,000, 1,000, 2, and 1. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Showalter. Miss Salisbury. Alfred Bridges. Sorry about that, Deputy Boris. I bet you, I don't know if your air is still fixed. I just noticed that one was there. All right, this is position 3, Bostic 2.0, 23 CP 222577. Alfred Bridges, 306 days without an indictment. Battery, willful obstruction, felony, and aggravated assault. There's an $18,000 good bond as of June the 12th.
11 adult arrests, a 2013 misdemeanor conviction for criminal trespass and theft by taking, a 2014 felony conviction for criminal use of an altered ID, theft by receiving stolen property, and carrying a weapon without a valid license. In 2014, the defendant received first offender treatment for aggravated battery, 3 counts. A 2019 felony conviction for escape, nothing further.
All right, go ahead, Ms. Salisbury.
Yes, Your Honor, I would be asking for the bond to be cut in half, so a $9,000 bond. Mr. Bridges is 28 years old. He does have a 5-year-old son. He is originally from Atlanta. His whole family is here. He would be residing in Fulton County if he were to be released on bond. Prior to his arrest, Mr. Bridges was not working due to him being a full-time caretaker for his great-grandmother. Since Mr. Bridges has been in custody, the family has had to hire or pay for home health aides. Mr. Bridges did graduate high school in 2013 and had received a trade in asphalt and road maintenance. So I would be asking for the bond to be cut in half, with count 1 to be reduced to 1,000, the other 2 to be reduced to 4,000 apiece.
All right. Ms. Rhodes, any contact with the victim?
No, Your Honor.
All right. Go ahead, Mr. Malkin.
The defendant has a very violent criminal history, and these are very violent offenses with which he is charged. The state believes that he does pose a significant danger to the community and risk of reoffending and danger to the witnesses and victims in the case. And the state is requesting that the bond remain the same.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. When you get out, you're going to have a 24-hour curfew, court, lawyer, medical. Also be medical for his great-grandmother.
Yes, Your Honor.
Great-grandmother, if you're her caretaker and you have to take her. And I believe this happened over at the jail. So No further violent contact with Theresia, Thyrecia, Oden, Oden, a detention officer. And that goes in every other detention officer that works at Fulton County. There should be absolutely zero contact with any of them of any violent nature. Yes, ma'am. Yes, sir. No, sir. No, ma'am. That's all you need to do with them. All right. So, like I said, you'll have that 24-hour curfew. Make sure you keep your address updated. So 2,000, 7,000, 7,000. Best of luck to you, sir.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. All right. So we got Anthony Wilburn. Wave your hand. There we go. All right. Let's see. It's position 2, 24 PI 001280, 170 days without indictment. $40,000 good bond as of June the 12th on aggravated assault. Wow.
16 arrest cycles, a 2010 felony conviction for possession of possession of cocaine, a 2011 felony conviction for entering auto, another 2011 felony conviction for purchase, possession, or sale of marijuana, a 2014 felony conviction for purchase, possession, or sale of marijuana, 2017 felony conviction for possession of a firearm by a convicted felon, a 2018 felony conviction for forgery, theft by receiving stolen property, possession of tools, and theft by shoplifting, 1 FTA in 2017. Nothing further.
All right. Go ahead, Mr. Surgeon.
Thank you, Your Honor. Mr. Wilborn is 33 years old, a lifelong resident of the state of Georgia. If released, he's going to reside in Decatur with his family. All of his family is local here in Atlanta. As you heard, he has some history. However, he's been in now 170 days without indictment. Last time we had a hearing here before Your Honor, the state maintained that this was a serious violent crime, and in the time since, they have not moved on the case at all. There's been no indictment. And so while Mr. Wilborn continues to sit, there's been no movement on his case as far as we're aware. And so for those reasons, we're asking for the bond to be reduced to something that Mr. Wilborn can actually afford. And that would be in the amount of $10,000. We understand the allegations are serious and the history is what it is. But if it is that serious, we would hope that at least an indictment would be coming soon.
All right. Any contact with the victim, Ms. Rhodes?
No, a victim locate was sent.
Okay, go ahead, Mr. Malkin.
Thank you, Your Honor. Mr. Wilborn has a significant criminal history, and this is a very violent case. That indicates that there is a significant likelihood of reoffending. He also does have a history of failures to appear. The state is requesting a $35,000 good bond.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 911 Joseph E. Boone Boulevard. Stay out of Fulton County. The only reason you darken the doors of Fulton County, sir, is court, lawyer. That's it. Nothing else. If you have to come here, you need something to eat, stop outside of Fulton County and get it and have it in the car with you. All right. And no, do we have the victim's last name? Because I just have John B. I don't know why. Excuse me, the alleged victim. That's all that I have.
Got John Britt, B-R-I-T-T.
All right. John Britt, B-R-I-T-T. No further contact with him. $35,000 good bond. Best of luck to you, sir. And then I got Isaac McPherson. All right. This is a position 1 add-on 23 CP 220700, loitering and prowling, burglary in the second degree, willful obstruction. And this is a hearing on the FTA that was correct, that was issued on April 25th. Right.
26 arrest cycles, a 2001 felony conviction for burglary. In 2004, the defendant received first offender treatment for burglary, and that was sealed in 2019. In 2022, there's a felony conviction for removal of a weapon from a public official, possession of a firearm by a convicted felon, 3 counts of aggravated assault and robbery. And the defendant does appear to be serving an 11-year sentence on probation for that. In 2024, there was a felony conviction out of the cab for theft by shoplifting, and the GCIC is showing a warrant for this case. Nothing further.
All right. Go ahead, Mr. Surgeon.
Thank you, Your Honor. Mr. McPherson is 54 years old. He is a lifelong resident of the state of Georgia. He does have a good address in the Atlanta area, Your Honor. At this time, we're asking that the FTA be set aside and a bond be instated in this case, that amount not to exceed $10,000. He was previously arrested on a $10,000 and had a $10,000 bond and was given an ankle monitor. We had some issues with that. And so we have the FTA now. We're asking for a bond to be reinstated, the FTA to be set aside.
So is there a reason he didn't show up on April 25th?
Your Honor, my understanding is that he was not aware that he had court that day.
Okay, so, sir, it is your responsibility to keep your address and contact information updated with the court, and definitely your lawyer so he can update the court, because notices are sent out, and if you don't keep it because they were sent out, if you didn't get it, you didn't update whatever information, and that's a you problem. That's not your lawyer's problem or the court's problem, so that's a you problem. Go ahead, Mr. Malkin.
This gentleman has looked a gift horse in the mouth, and now he's back on a failure to appear. The state would request an $18,000 bond, 15 on the forgery, 1 on the loitering, and 2 on the obstruction, please.
All right. So we can reinstate it with the previous conditions with loitering and prowling at 1, the burglary 15, and obstruction for 2. So, Ms. Robinson, you can just take the previous, let me see. Let me see what, I'll put it on the record. Hold on. Wait.
I got it, Judge. Just reinstate what's on the original bond order.
Yeah, let's see, make sure. I think that original bond order it's the October the 12th. Let's see. Because there's one that was right before it, and then October 12th was a consent. Let's see.
Okay. But he'll need to make a new bond on this one, correct?
Right. So yeah, just put those and then, yeah, and then all the conditions that were on the October the 12th with the amounts. All right. Best of luck to you, sir. Thank you, Mr. Surgeon.
Thank you, Your Honor. Apologies for my tardiness.
No, you're good. Y'all are busy. I know. All right. So you can leave the booth. Miss Lewis. Oh, and Miss Lewis, I want to thank the people at this PAD, the people that gave me the Lifetime Achievement Award. I hope that doesn't mean that it's the end of my life. However, Ms. Lewis, Mr. Malkin wants to know if there's going to, because I don't see one yet, a calendar next Thursday.
We sent the calendar out last week. You talk. Wait. I'm sorry. No. No, I'm sorry. I'm in my 40s. Hold on. I'm thinking about that doggone compliance calendar. Lord.
Oh yeah, no.
If it's not a calendar yet, it's coming out. Let me double check and see if I see it on mine. Judge, do you see it?
No, right now it says 0 of 25 on the 15th.
Okay. He might have been still building it. Mr. Dukes is out until Monday, but no, we have no plans to cancel night court next week at all.
Okay, so if something comes up and it does it, we'll let Mr. Malcolm, will email y'all and let you know.
For sure. Yes, I'm sorry. I was thinking about Tuesday.
Oh yeah, that 100-person calendar, that's fine.
Yep.
All right. Thank you, Mr. Malcolm. So we'll let you know they're looking for it to come out.
Great, thank you. I won't be here next week. I will be hiking in Wyoming at 12,000 feet. So, but I'm sure Mr. White will be glad to be here. And I understand there's a new calendar, some sort of a compliance calendar.
Compliance calendar on the
Orca is the gift that keeps on giving.
It's good.
We were tasked with it's really technically an ankle monitor violation calendar. Trying to bring people into compliance, and apparently the new monitor company is supposed to also be in court. It's just it's a interesting combination of case types. That's the best way I can describe it.
There's one at 9 a.m. No, it's just the 13th. There's one at 9 a.m. There's 41 cases on 9 a.m. and 36 at 1 p.m. And
wow.
If they're in court, stuff, it'll work out. So I'm sure all of them won't be a hearing, but
Mhm.
Yeah, she sent that out, and then I guess we'll have these as we need them if we have something else that comes up where we gotta like get it moving.
All right, and Mr. White is aware of it, so he can arrange for it to be staffed by our office?
He should. I sent it. I know Travoria, Miss Robinson sent it out, and I also resent to Miss Davenport and Mr. Jenkins
Okay.
as well.
Okay,
I didn't get it, Miss Lewis, but
You didn't?
no,
What?
you just like me to shoot from the hip.
Oh,
I did send that to you, Judge.
I said Travoria took a microphone.
Oh, she's laughing. She's laughing. She got it. She's laughing. I'm like,
I
But no,
didn't get
Mr. White should have gotten to Mr. Malkin, but
Okay.
we can err on the side of
he's
caution.
on
and
the
just resend it.
he's
Is
on
he
the
on the distribution
report
list?
list, so he
Okay.
received it.
Okay.
there you go. So
yeah,
everybody,
we get a lot of calendars, so
Yes.
they may have overlooked it if it's not something they were expecting. I don't know.
I
Yeah.
think he already accepted it.
Okay, all right, good.
all right. So, well, have fun in Wyoming. I'm jealous.